afternoon, committee. And today is the last day before we're on the floor for turnaround. And so we have 3 bills we will be working and to see where the House Ag Committee wants to go. Before we get into this, and I appreciate so far the first half of the session, we maybe started off a little slow and probably finished maybe a little too fast for some people's liking, but the process works the way it does. As a legislator, sometimes it's easy to vote on resolutions and, bills that pass 125 to nothing. But sometimes we do a disservice to the citizens of the state to not take on issues that maybe make us feel a little bit uneasy. If this was easy, I think everybody would always have people running against them all the time to want to do an easy job. And so I just want to thank you for your commitment to not only the community, the agriculture community, but also to the state of Kansas. And we got a few bills coming from the Senate that might be probably not quite as interesting as what we've tackled so far this first half. So, but we will have some ag bills over the next couple of days come before the Committee of the Whole, and so ask for your support as you supported them out of committee. So with that, we will go now to House Bill 2531, and we will ask Kyle Hamilton for a quick, again, explanation of this bill.
Thank you, Mr. Chairman. House Bill 2531 would allow certain persons to use the right-of-way of any county road or township road to install, maintain, and operate one or more pipelines for agricultural activities. The bill would grandfather in pipelines used for agricultural activities that were installed prior to the effective date of the bill, except for pipelines installed in violation of an express prohibition of the Board of County Commissioners in effect at the time of such installation. An application to install the pipeline would need to be approved or denied by the Board of County Commissioners within 60 days of receipt, or it would be deemed as approved. The owner of the pipeline would be responsible for the maintenance and repair of any such pipeline. Agricultural activity would be defined to mean the growing or raising of horticultural and agricultural crops, hay, poultry, and livestock, poultry, and dairy products for commercial purposes, and would include activities related to the handling, storage, and transportation of agricultural commodities. Thank you, Mr. Chairman.
Any more questions for Kyle? Representative Carlin.
Thank you, Mr. Chair. Kyle, I didn't hear you say, and I've got a copy here somewhere, what kind of notification is given before it goes into automatic approval at 60 days?
There would be a required public hearing before the Board of County Commissioners.
And then it starts the 60 days? Is that how you read that?
So it's within 60 days of receipt of the application by the county clerk.
So the public hearing could be 2 weeks later, or I don't know. I mean, I don't know if that's what I'm asking.
Correct.
So notification is of a public hearing, and 60 days after the hearing, it's automatically approved if it hasn't been voted down.
Right. There would be reasonable notice and an opportunity for a public hearing, but if the Board of County Commissioners doesn't approve or deny the application within 60 days, it's deemed to be approved.
Okay. Thank you so much. Thank you, Mr. Chair.
Committee, what is your pleasure on this bill? Representative Newland.
Thank you, Mr. Chair. Kyle, would you reiterate the part of maintenance of the right-of-way?
So language concerning that topic can be found on page 2, starting on line 9. A county commission or board of township trustees may require the owner of a pipeline to repair, all damage to a road or road right-of-way caused by activities of such owner or by any agent, affiliate, employee, or subcontractor of such owner while they are occupying, installing, repairing, or maintaining the pipeline in the road or road right-of-way. And then it continues on to subparagraph B. They could be required to return the road and road right-of-way to its functional equivalents before the damage pursuant to the reasonable requirements and specifications of the county or township.
Thank you.
I believe we have a balloon amendment. Is that correct? That's right. I'm sorry. You're right. So what is the pleasure of the committee?
I will move it.
All right.
Just for discussion purposes, I move that we pass out favorably House Bill 2531.
Here a second? Second by Newland. There we go. Now, I guess I will offer the amendment. I believe it's an amendment by the interested parties that came up with this. Yes. Representative Minix.
Mr. Chairman, I'll step in here. Several of us, after the last meeting, not a quorum of this committee, got together and discussed what we thought some of the positive points of this bill were and some of the shortcomings, and we tried to work out something which we thought was reasonable for the people of the state of Kansas. And I have not seen this myself in writing, but I want you to look at it closely and see if this helps this bill somewhat. Thank you, Mr. Chairman.
All right, thank you. We will review the amendment. Can you explain the amendment?
Thank you, Mr. Chairman. The first box on page 1 would amend the application process by requiring that the application provide the location of all locatable underground facilities in the area of the work and in the vicinity of the excavation. And the applicant would have to notify each owner of such underground facilities. And then the second box would increase the number of days that a Board of County Commissioners would have to consider a pipeline application. That would be increased to 90 days. And then flipping to the second page, the first box would state that making its decision, the board they could consider whether the pipeline interferes with the management of conflicting uses of the road right-of-way. The second box on page 2 would require the pipeline owners to provide notice to the county of any maintenance activity that may require the temporary closing of a road or obstruction of traffic. The third box on page 2 would state that a pipeline permitted under this act and installed on or after the effective date of this act shall be a locatable facility as defined in KSA 66-1802G. That statute has been attached to the balloon so you can see that definition. Locatable facility is defined to mean facilities for which the tolerance zone can be determined by the operator using generally accepted practices such as built-in construction drawings, system maps, probes, locator devices, or any other type of proven technology for locating. Thank you, Mr. Chairman.
Okay, questions, comments on the amendment? Representative Minix.
In our discussions, this does a pretty good job of eliminating what we were discussing at that time. We extended the time period to 90 days. We wanted to make this process as transparent to the public as possible so that all parties along the length of this proposed pipeline within the right-of-way would have good notice, and they could provide their comments prior to any construction going forward. It would be locatable. The statute would allow for, what is it, the 511, 811 system to be utilized, or whatever's appropriate in that area. And so I think it's a step in the right direction, and I hope you can support this. And if not, if you have some amendments that can improve it, we'd welcome that. Thank you, Mr. Chairman.
Representative Carlin?
Thank you, Mr. Chair, and I have no decision on this. I am still learning. I've just been in local government, and I know how it is for people to know what's going on in local government. It's not that they aren't telling us, but we aren't always listening. So my question is, I appreciate the extra time for the public. Is the extra time detrimental to the project? Minix, you can, Representative Minix.
Representative Minix?
If I could respond, yes, it would be. But we wanted to allow plenty of time for notification for people that are adjacent landowners to have time to digest it, and for plenty of time for all parties to come together. I think it says up to 90 days, and then it would become law. If all parties agreed to it, I don't know why this couldn't happen at a sooner time period than that 90 days. If they all agree within 20 days and it's not a problem, I think the project should be allowed to move forward, was what our intent was. I'm still trying to understand if our language here actually says that. Maybe the reviser can help me.
Yeah, go ahead. I have one.
Well, in order to make sure, let's have a reinstatement of your intent. Could you clarify what you want it to mean?
What I would propose is a time period of notification up to 90 days, and if no major objections have come forward from anyone adjacent, then at the end of 90 days, the county commission would be authorized to approve or to allow this to go forward. However, if all parties that are involved make notice to the county commissioners within 5 or 20 days, if all parties agree to it, then I think the project should be approved by the county commission and allowed to move forward.
That language is not in the balloon. So if you would want it to be, it would kind of need to be, I guess, conceptually added onto it. Because as of now, the decision would ultimately be up to the county commissioners. They would have an open hearing and they could get input from all of those possibly affected property holders. But even if there were disagreements, it would be the county, the board, that would make the final decision.
Let's ruminate on that just a bit. Representative Orr?
Okay, yes, thank you, Mr. Chair. I really like the addition of the 90 days, but I do want them to be able to complete this if it's sooner. I think the 90 days has numerous benefits. Number one, if we got a dispute, there's nothing settles a dispute quicker or better than time. Let's let them simmer on it. Let's let them attempt to solve it themselves. And as soon as that's solved, I want the county commissioners to be able to step forward as quickly as they can after that. And I was hoping that this would read that way. So that would be my input. Thank you, Mr. Chair.
And in response to that, I believe it does read that they could come to their decision much sooner than 90 days. That's just the upper limit. But it would be the Board of County Commissioners that is making that decision within the 90 days. So it could be very soon.
Okay, just a minute. Representative Probst?
Thank you, Mr. Chair. Yeah, so I guess I thinking about some of my concerns and some of the conversations about what we might want to do on this, this seems to address specifically or be a little more tailored, and I'd ask the reviser to correct me if I'm wrong, other utilities that are already existing in the right-of-way. This is saying you have to notify a utility company if you plan on doing something in the right-of-way. And it extends that 90-day period from 60 to 90 days. the original bill had the public notice thing, but to me, one of the concerns it doesn't address for me is a clear obligation to involve the adjacent landowners or the affected landowners. That we're talking utilities, we're talking about things that are existing, we're talking about county right-of-way or interfering with traffic or maintenance. But I don't see anything that's a little more instructive, I guess, on making sure that we're making people be good neighbors. Am I wrong in my reading of that?
Well, I don't think I necessarily have a direct response to that question. There are additional provisions that would arguably help create more awareness of where the pipelines would be so that utilities and other entities would know where they are and be able to kind of work around them without causing issues. But other than that, I don't think I could really address your question myself. The chairman, if he wishes, might want to defer to the drafters of the amendment who are in the audience.
All right. Representative Carlin.
Thank you, Mr. Chair. Actually, that was my next question was, how are we informing the adjacent landowners? And I looked in the first part of the bill and I don't see it. And then, but reading the first line says upon approval by the Board of County Commissioners. So that means the process has already been going on for a while. There's been an application made, am I correct? And so the notification should be way before this bill starts. So are we amending, what are we attaching this to? Some other statute, no doubt, that should include notification, but I don't know because I can't see it. So it's notification of the adjacent property owners, that's my question. And the second question is it already in the other statute, how they're notified?
So I'll start off on a response, but then I might have to defer to the drafters. So the application that would be submitted to the county clerk would include a lot of the details concerning the location, and I'm sure that would be widely distributed in the subsequent public hearing. But I don't want to touch on the Kansas Underground Utility Damage Prevention Act. That's the 811 language we're talking about. We might want to get some more input from the drafters of what they intended, and then we'll see how well the language reflects it.
Other comments? Representative Probst?
I'm sorry, and I really, all I'm trying to do is make sure I understand, and I really want us to try to fix this problem, because I don't think we want to be in a position where we're prohibiting agriculture activity and not allowing this to happen in the right-of-way. Conversely, I don't think we want people's land to be affected without their knowledge and consent. And I don't know, to me, I'm not sure this language does this. I wonder, in the first box on page 1 that fits in on line 26, we put the onus on the application and the applicant, and we say that the applicant shall notify each owner of such underground facilities, but we then kind of leave the onus on the county commission to create policy, and it would be up to the county commission to make sure they notify the affected landowners. I wonder if we would entertain an addition to that clause that said the applicant shall notify each affected property owner and the owner of such underground facilities.
Representative Carlin?
I believe in city government, when we had any kind of zoning issues, once the application was made to the governing body had the obligation to notify the people, because they have access to all the information, who they are and how to reach them. And so I would say, instead of the applicant shall notify the governing body, which is always a county, I don't know, but the governing body that's reviewing the application should notify all of the adjacent property owners. They may be in other states. I mean, we don't even know. So if that's amenable, I would make that amendment to the amendment if that's appropriate.
Mr. Chair. And I would defer to people who have experience as county commissioners on this to say what the best process is on this. My goal is just to make sure that property owners are notified about what the intent is to do with their land. And I don't really care how we get there, just as long as it's clear we want that done.
Okay. Representative Minix?
I actually agree with what you guys are saying entirely there, as far as the county doing the notification to all adjacent landowners. And that was my intent somewhat from the beginning. So I would second Sydney's motion if that was a motion.
That was.
And I'll be honest, within this bill, if I could say a few more comments, there was something left out from our prior bill that dealt with grandfathering. I would like to see that come back. After our discussion the other day, some other people took this information and did some drafting with it, and maybe we should have them come to the mic and give us some information, and we might be able to fill in some gaps here.
Okay, we'll see. First, we'll call on Representative Carlson.
Thank you, Mr. Chair. I can't read through this quickly enough, but on the last page, when it gives definitions, in said person, it means any individual, partnership, corporation, association, franchise holder, state, city, county, or any governmental subdivision or employees, agent, local representatives. I'm not sure where that comes in because I couldn't scan it quickly enough, but I mean, that does give it a definition of any individual. It doesn't say landowner, next to, but anyway, that's all. Thank you.
All right. Representative Minix. Anything? All right. Okay. Let's go back. Let's take a step back. So do you have an amendment?
Oh, no, I think maybe, no, he was wanting someone to come to the mic. I can't remember.
Do you have an amendment or not?
You made a motion to add that.
Oh, and he seconded it. Oh. I close on my amendment.
Okay, so can we, we need some clarity for sure on that amendment.
If we could just distill.
Okay,
If that was an amendment.
My
So-
amendment would be to replace the word applicant in that box amendment where it says, and the applicant shall notify. I would say, replace applicant with the governing body shall notify each owner of such underground facilities. And each owner? Oh, I thought it said each owner. So, okay, if it needs adjacent landowners, all adjacent landowners. So what did I just say? The governing body shall notify all adjacent landowners of such underground facilities.
And maybe Kyle can make sense of that.
Yes, Representative Syward.
Thank you. Several of us have a conversation here. Being on the township board for 30 years, we dealt a lot with right-of-ways too, and fences and everything. You can shake a stick up, not quite like the county commissioners do, but on a face-to-face deal. Most time, anytime a utility or somebody was going to come in, they put it in legal publications or notified it in the local newspaper. But it was almost next to impossible to notify each adjacent landowner because as long as it's in the right-of-way, you really didn't have to have permission for doing anything until you got on the customer's private property. Once it was on the private property, you could have it surveyed by the county. The county would come out and survey it and mark it. And as long as you stayed on that side, you didn't have to have permission from the landowner. Now, most of them was okay with it because we fixed the roads for them, see. So I don't know if this would, the way it is currently amended, that it's working, that would answer those questions. But if we set foot on the customer's property, then it changed the whole way we did things. And that was what we tried to go in and talk to them at that time if there was a problem. whether they're going to plant trees on the right of way or, whatever they're going to do. So my opinion is it might work okay if the notifications, like the county does what it says, because can make it too complicated too. So that's my opinion as being on the township for 30 years also. I'm a professional government employee, sorry.
Okay. That was not a substitute motion, correct? All right, for the amendment. So can you explain again the amendment?
So I wanted to get some clarification because I think we need to untangle the owners of underground facilities, which could include utilities and just any of those different underground pipes and things, and then the owners of the adjacent land. I think you want those to be two separate entities, like people who are getting notice by the county. Okay. So I might not have the exact language like right here to say, but I could figure that out. But that's why I wanted to clarify. We're talking about like two individual groups of people, essentially.
And you want that notification done by?
The governing body.
By the governing body.
The governing body of whatever it is, if it's a township board or a county or a city, I don't know, but the governing body that governs that area.
Okay, now we'll discuss, Representative Seibert.
And I understand what you're saying. Again, if it was off the right-of-way, we did contact them. We wrote them a certified letter to note that we were going to be on the property, even had to cross property or take some of the bank away to make it the legal angle or whatever. And the same way with filling any damages that we had a lot of issues sometimes with telephone contractors or cross pipeline going across property and across right-of-ways. That was a little different. But I think once it's off the right-of-way, then you got to notify them personally as a courtesy to the landowner. But technically, that's be a lot of work on that person's part to notify everybody along that route.
That's why I said the governing body should notify.
Yes, okay.
Because I don't think the applicant should be responsible for knowing how to reach every single one of those people. But
Thank you.
the
That's why
governing body
yeah.
has access and staff.
Thank you. That's the
Yeah.
same. I agree with you 100%
More
there.
discussion on the amendment? Seeing none, you may close.
Thank you, Mr. Chair. I think this, I think it's really important that we be sure that all the people affected have information about what's about to happen around their property, and that's why I made this motion. Thank you, Mr. Chair.
Okay. All those in favor of the amendment, signify by saying aye. Aye. Opposed, same sign. Amendment carries. We're back on the bill. Representative Carlin.
Mr. Chair, I believe Representative Minix was asking something about grandfathering, and I didn't follow that. I don't know if we're ready to move on or if he has more information he'd like to offer.
Mr. Chair,
Yes.
our prior bill before this did have a grandfathering clause in it. And I would like to see that to prevent some future litigation. In lots of areas, there already currently are lots of pipelines that cross the road right-of-ways or go down the parallel ditches. And those have been generally clean water lines in the past, but I think they should apply also to this so that we're more uniform in how we apply this stuff. So I would like to see that grandfather paragraph that we had prior come back into this. And so I would move that we bring that paragraph back to this particular bill, to 2531.
Do I hear a second? Okay, moved and seconded. Discussion. Reviser is trying to find where that is.
Well, so I wanted to just ask directly before I go searching, if you could be a little more specific, Representative Minix, about what the previous bill you're referring to and exactly what change, I guess, impact it would have on the current language of this bill.
Was there at the beginning? I don't remember.
At this time, I'm failing to find that in the copy that I have, but I believe there was some reference to it earlier. Am I totally mistaken?
Earlier, sorry. Mr.
That's
Chairman.
fine. I'm going to call on Mr. O'Neill because I believe you were one of those that helped work on the balloon and clean up some of that language. Is that correct?
Yes, and I believe, as Kyle pointed out, the grandfather clause is still in. It's in subsection 1B. Correct, Kyle?
Yes, that's correct.
Thank you very much for the clarification. I would take back my
withdraw
prior
your
motion.
amendment?
I withdraw.
Okay. All right, other discussion? Is that all we have? Seeing none, we will hear a, what do you want to do now as far as this bill? That's right, I'm sorry, you did. We had a lot of discussion, so Representative Carter, you may close.
If there's not anybody else that has a point to make, I would close on my motion and move we pass it out favorably as amended.
Did we miss something or not?
A second.
Okay, all right. All right, with that,
I would
Representative
second
Menace.
the bill.
Okay.
The motion.
All right. Okay, you've heard the motion. All those in favor of passing out House Bill 2531 as amended, signify by saying aye. Aye. Pose same sign. Motion carries. Bill is up next will be House Bill 2532. All right, Kyle, if you could explain what this is?
Thank you, Mr. Chairman. House Bill 2532 concerns the State Board of Veterinary Examiners and the regulation of licensed veterinarians and registered veterinarian technicians. It makes various updates relating to penalties, fees, and the investigative and disciplinary proceedings of veterinarians and registered veterinary technicians. Thank you, Mr. Chairman.
Any questions for Kyle?
Oh, I might add just one more thing. I forgot. When we had testimony, there was a balloon that was attached to the director's testimony, and that's been distributed. I don't know if anyone had a chance to look at it, but
Committee, what your pleasure on this bill? Representative Moser.
Thank you, Mr. Chairman. I move that the Ag Committee pass out favorably HB 2532.
Here, second? Seconded by Thompson. Discussion, Representative Moser.
Yes. Okay, sit back and relax, because this might take a few minutes. But when I was first introduced to this bill back on January 27th, I figured it was a slam dunk. We'd update the Veterinary Practice Act, which in the past was updated in 2015 with some minor technical statements. There would be no surprises for the vets in good standing in the state of Kansas. There was no money involved, no fee increases. You know, I thought it was an easy yes. Honestly, I wasn't prepared for the pushback that I heard at the bill hearing last Thursday, but now I'd like to share with you a backstory, which I think will shed a lot of light on the current situation. Prior leadership in the KBVE had not been following through with disciplinary measures concerning complaints filed against licensed, unlicensed, or non-licensed veterinarians. And this had been going on for the past 5 to 7 years. This caused a mistrust to develop between the Kansas Board of Veterinary Examiners and the Kansas Veterinary Medical Association. So since Thursday afternoon, I've been in talks with both sides, Friday, Saturday, emails on Sunday, meetings again today, and I'd like to share with you how they feel about this and how they look at going forward. The three items that were called into contention on Thursday at the hearing were cite and fine, recouping fees, and the determining if someone was an impaired veterinarian. So I'll go through them quickly. And so with regard to the cite and fine, that's been in agencies for many years. But in North Carolina, 8 years ago, there was the North Carolina Dental Board, there was an unlicensed person whitening teeth. And the dental board thought, you know, that person was infringing on the dentistry profession, and so they took action. The Supreme Court found in favor of the layperson, and it broke North Carolina's dental board, and each volunteer member, I think, ended up paying $100,000. And so when that came through, agency lawyers were in shock and have since recommended that cite and fine be removed from these types of legislation. So that's why the KBVE recommended to have cite and fine taken out, and that that veterinarians that were having issues would be dealt with in a different way. So the second item was recouping fees, and that is when the fees that are incurred if a veterinarian is found in error, that veterinarian has to pay those fees, because membership is based on fees, and if the KBVE, you know, would be required to cover those costs in a lawsuit, they're going to have to charge more to keep their coffers full enough to pay for those fees. And 99% of the veterinarians in Kansas are upstanding, good, they do their work well, they document well, whatever. And so I was approached by veterinarians that said, you know, why should we pay for the people that are in error? So that made sense to me, and so the recouping fees would be, you know, that's how the KBVE would deal with legislation or litigation. But I've also been reassured that they're not going to go into litigation unless they know they have a slam dunk case, that, you know, they're not going to do unnecessary litigation. So, and the third thing is impaired veterinarians. And we all know, especially in the last 2 years, what stress has done to mental health of everybody from veterinarians to short cook waiters at the restaurants. So ultimately, the Board of Veterinary Examiners has the final say whether a veterinarian that's brought up is impaired, but they're not going to do that unless they have a professional evaluation done. And that veterinarian can choose to go to his own doctor, to go to a mental health evaluation, or the KBVE works through the Heart of America Professional Network. And that individual would be evaluated by professional staff, and then their recommendations go to the board. So those three things that were issues last week have been worked through and addressed, and they're clarified in this bill and an accompanying balloon amendment, which I have. So I believe that this bill and all of its proceedings has brought out the angst between these two organizations. And I mentioned that earlier in the backstory. I believe it's been brought to light and it's being resolved. And I really believe that members of these two organizations want to move forward. Trust is being rebuilt to come out of the current situation even stronger than ever. They want to see the Veterinary Practice Act updated in a positive way, not only for all Kansas veterinarians, but for the citizens of Kansas. And with that, I have that balloon amendment.
Pass that out, please.
I have one, thank you.
Representative Mosier.
I might add, on the impaired veterinarian number, it's not just mental health. It would be, you know, if a veterinarian is an alcoholic or addicted to drugs or whatever, anything that would cause them to not be able to perform their functions, they would be professionally evaluated, and then that result back to the board.
Representative Mosier, do you move your amendment?
Yes, I move the Ag Committee, move it out.
No, we don't, no. We don't have to move it out. We need,
Move to amend.
Oh,
move to amend. I'm sorry. So you need to do.
okay, before we discuss it? Yeah.
You move to amend, then we
I move-
discuss.
I move we
Yes.
amend the
Move to-
bill,
Yes. Second.
amend the motion.
Second by Newland. Discussion, Representative Carlin.
Thanks, Mr. Chair. Well, I haven't quite figured out the amendment yet, but the question I have is, what is the basis for collecting fees from veterinarians? What is their fee fund for? Tell me why do they pay fees to the state of Kansas, or who do they pay it to? I mean, I know when we swept fees in '03, what happened? So everybody had over $200,000 and they lost it. So what do we do with the fees when they're collected? What is the purpose of fees?
Representative Mosier.
I might defer to one of the veterinarians on either side.
Dr. Olson, if you would address the committee, please.
Just for clarification, Representative Carlin, are you talking about the fees that come into the agency for fee funds, or the fees we're talking about in litigation?
I'm wanting to understand that better. I just don't know. I didn't know there were two kinds of fees.
The Board of Veterinary Examiners is a fee-funded agency that collects all, the way we operate and get our income is on licensing veterinarians, registering veterinary technicians, and then all the premise facilities need to be registered to have a veterinary facility, and whether it's a brick and mortar or a mobile veterinary practice or a veterinarian that just works out of his pickup. That's how we collect our fees to run our day-to-day operations, as far as to take care of the salaries of our 4 staff and run the operations of the business. So that is where the fee funds come from, and they come from veterinarians and technicians. Now, in regards to the second part of your question, in regards if there's a complaint that requires a legal process, if there's a complaint on me as a veterinarian, and that complaint is investigated by our investigator, and it goes before our probable cause committees to determine if there's a violation of the Practice Act. If they don't find any probable cause on me, there's no fees that are involved back to the licensee. But if there is probable cause that is involved on me, and I don't like the outcome of that finding in regards to the discipline that the board finds on me, then I have the right to a hearing. And I can go to the next step in the legal process. And if I don't like the outcome of that next step, I can go on up the ladder, all the way up that, and I hire an attorney and deal with those fees. And so in regards to that part of the veterinary fee fund, we don't collect fees for that. We're very careful on how we move through. If there's no violation of the Practice Act, we report back to the complainant, we report back to the licensee or to the non-licensee whether there is a violation of the Practice Act. So if there is a process, we don't have a fund sitting over here for litigation, so to speak. We have a contract with our litigation attorney, who's also our general counsel, for a set amount per year. And once that goes over that, some of these difficult cases in the past, which are very rare, we've had cases that might cost $20,000, $30,000 or $40,000. But In most situations, it fits within our normal council amount. So that's how we answer that question. Does that answer your question, Representative Carlin?
Thank you, Mr. Chair, and thank you, Mr. Olson, Dr. Olson. So is your board a judgmental body? They're making a judgment on, does your board judge the complaints?
Our board takes the information from our investigator in a complaint, who puts all that information into a packet, and there are 2 probable cause committees made up of 3 veterinarians in probable cause committee 1 and 3 veterinarians in probable cause committee 2, and our 7th board member is a non-veterinary public member that is called into a case if one of those veterinarians is not involved. And our decision whether there's probable cause is based strictly on what's statutory authorized in the Kansas Veterinary Practice Act. If there's a violation.
So you do make a judgment?
Yes, so,
Your
but I just wanted
board
to.
is the judgment. That's what I was trying to
The
get.
board makes the final decision in regards to whether there's a violation.
So there's no other litigation about this? I mean, it doesn't go from you to another, to the district court or?
It can.
So
But
what if it does? Who pays for that?
that is up to the licensee to go to that, because that's out of our jurisdiction then. That's handled by the licensee.
Do you have malpractice insurance that would cover those things?
Professionals
Like-
have the opportunity to buy professional
But it's not
liability insurance.
required? It's not required, it's just an
It's highly
opportunity.
recommended.
Yeah, okay.
It's highly
Thank you.
recommended.
Thank
Thank
you.
you.
Now
I don't
I
wanna-
understand
I don't wanna do
better.
another
Thank you. Thank you, Mr. Chair.
Rehearing of the bill. So, but I understand. Thank you. Other questions or comments on the bill? On the amendment, I'm sorry. Let's have an explanation, though, of that amendment. We kind of went off on the other way there.
Thank you, Mr. Chairman. The balloon touches on a number of different things, so the best I can do is sort of lead you guys through it page by page. So starting on page 2, line 39, there would be a change to the definition of practice of veterinary medicine so that it would include prescribing, dispensing, or the administration of any drug, medicine, et cetera, et cetera. Page 3, the definition of probable cause committee would be deleted from the draft, and references to the probable cause committee throughout the draft would also be removed. And then on page 10, line 42, there's a requirement for veterinary technician registrants. The registration has to be renewed upon payment of a renewal fee, and then they have to provide evidence that they've participated in a certain number of hours of continuing education. So this balloon would raise that amount from 8 to 10 hours. Then a small change on page 13, line 14, just inserting the words "of the practice" before "of veterinary medicine." Then page 14, striking references throughout the page to companion animals. Those strikes are on lines 14, 29. And then on lines 38 and 39, the language for written notice when an animal is placed in the custody of a licensed veterinarian, that they're supposed to give notice to an owner of the animal, and it would be changed to say, after written notice is reasonably attempted to be given to the owner or the owner's agent, and then the balloon would strike out some of the qualifying language saying by registered or certified mail return receipt requested. That language would be removed by the balloon. And then page 15, strike a new strike in line 18, striking operating and managing veterinarian. And then I'll read that sentence as it would now read. Any existing premises shall be inspected and registered by the board within 60 days of any change of the licensed veterinarian who is responsible for the operation and management of the veterinary premises. And then line 26, similar changes. And then final page, removing one of the references to the probable cause committee. So determinations of reasonable suspicion of impaired ability. The investigative information that would be used is presented to the board as a whole, not a probable cause committee, which from what I understand usually was composed of about 3 members of the board, but now this would just refer to the board in general. Thank you, Mr. Chairman.
Thank you. This is primarily technical in nature, a lot of cleanup as far as substantial changes to the original bill that's not there. So, Representative Orr.
I would just like to thank Representative Mosher for the work on this. I know she had a really full weekend, and I would just add that I had one constituent call me that was working with this amendment, and he is totally in support, so I am going to be in support of this amendment.
Thank you, Mr. Chairman. I close on my motion and move we pass out House Bill 2532 as amended.
Good try.
I close on my amendment.
Aye. Same sign. Amendment carries. Back on the bill. Any other comments or questions or other amendments on 2532? Seeing none now, Representative Mosher, you may close.
Thank you, Mr. Chairman. I close on my motion and move we pass out House Bill 2532 as amended.
You have heard the motion to pass out Bill 2532 favorably as amended. All those in favor signify by saying aye. Aye. Opposed, same sign. Motion carried. One more, which would be 2605. There we go. All right, Kyle, if you would give us the explanation of this bill again.
Thank you, Mr. Chairman. House Bill 2605 would increase the rural population requirement maximum for the veterinary training program for rural Kansas, and it would create a food animal percentage requirement that could be fulfilled in lieu of that population requirement. As noted in my brief, I would ask that there would just be a small technical amendment made to the bill on page 4, line 7, to strike the words "first year." The intent of the bill is to open up the program to students even when they're not in their first year. So that was a reference that I had missed when I originally drafted the bill. It's actually Representative Minix who pointed it out. So thank you very much.
Is that okay with the committee to accept that technical amendment? Very good. Okay, committee, what is your wishes on this bill? Representative Newland.
Thank you, Mr. Chair. I move we pass out HB 2605 favorably for passage.
Questions or comment? What's that? As amended, yes. Accept that. And seconded
Yes,
by Mosher. Discussion. Representative Minix.
Mr. Chairman, when this bill first came to us, I did receive some communication from veterinarians that were concerned that we weren't doing something for those people who studied out of state that came to Kansas to practice in some of these rural areas. After actually my wife's investigation here, the federal program allocates quite a few dollars, and that area would be covered if those individuals that come back to rural parts of Kansas that had studied outside of the state of Kansas, away from KSU Veterinary Medical College. There are provisions for them, but I think it's something that we need to look at in the future and possibly add to to what the state does provide, but there are some federal dollars out there, and they're fairly significant. If people have questions afterwards, I can show you maps and the website to go to get a lot more information on this. Thank you, Mr. Chairman.
Very good. Do you know the dollar amount? Did you happen to find that compared to what this program offers?
If an eligible applicant has to have at least $15,000 in qualifying debt, and it looks like competitive awards up to $75,000 are made for at least 3 years of service in it, and that's 3 years. I believe the bill we're currently looking at, it says 4 years. 3 years of service in a designated shortage situation, and the federal USDA determines on their map what an area with shortage is, and it's somewhat different than the state's version. So I'm not sure. I'm sure there's something in here that says the total dollars, but it's a significant program that is available to those people. Thank you, Mr. Chair.
Very good. Thank you for the insight. Other questions or comments? Seeing none, Representative Newland, you may close.
Thank you, Mr. Chair. I move I close on my motion on 2605, that we pass it out as amended.
What's that? No, sir, no. All right. You've heard the motion to pass out House Bill 2605 as amended. All those in favor signify by saying aye. Aye. Opposed, same sign. Motion carried. There we go. Our work is complete for this first half of the legislative session. Got out a half hour even early, so I'll take that half hour here in a couple weeks. I don't know yet. I'll talk to you in just a minute. All right. So with that, again, thank you for your efforts. Watch your emails. We will probably not meet until Wednesday or Thursday. That would be the 2nd or 3rd. So we will work on that. We will not be meeting on Tuesday when we come back till we kind of get some things lined up. But we are, if there's also things that you want to have discussions on, let me know. We're planning on industrial hemp, some other type of agriculture interests. We're trying to get those things worked out so that we can learn more information. So with that, again, thank you so much, and we'll see you on the floor tomorrow. We are adjourned.